Hello there. Welcome to video number 120 from Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now and press the bell icon so that you do not miss out on my previous or future videos. And don't forget to like and share this video. And to make your life easier, here is a complete list of all the videos available on my YouTube channel, listed under the playlist in which they are available on my channel. Have a look. In this video, we shall talk about the Indian perspective to green governance. I do hope that you have had a look at my earlier video on green governance. India is one of the few countries in the world which has enshrined in its constitution a commitment of environmental protection and improvement. Although some provisions in the Constitution relating to improvement to the quality of life had been made since its proclamation in 1950, a direct reference to environmental protection and improvement was introduced with the Constitution's 42nd Amendment Act of 1976. It was perhaps the UN Conference on Human Environment, held in Stockholm in 1972, which significantly influenced the government's awareness regarding the necessity of legal and organizational framework for protection of the environment. It has interjected a new dimension to public responsibility by making it obligatory for the central government, state governments, and every citizen to protect and improve the environment. The 42nd Amendment Act added twofold provisions in the Constitution. On the one hand, it directed the state for the protection of the environment, and on the other, it cast a duty on every citizen to help in the preservation of natural environment. Article 48A of the Directive Principles lays down that the state shall endeavor to protect and improve the environment and to safeguard forest and wildlife of the country. Article 51A specifically refers to the fundamental duty regarding environment. The article says it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Further, the directive principles of state policy in Article 47 clearly underlines the environmental duty of the state to improve public health. There is no direct provision for the protection of environment in the fundamental rights, but the High Courts and the Supreme Court of India have read the right to wholesome environment as part of the right to life guaranteed in Article 21 of the Constitution of India. Article 21 enunciates that no person shall be deprived of his life or personal liberty except according to procedure established by law. The slow poisoning by the polluted atmosphere caused by environmental pollution amounts to violation of Article 21 of the Constitution. In fact, the right to life guaranteed in Article 21 embraces the protection and preservation of nature's gifts, without which life cannot be enjoyed. Moreover, environmental degradation has disastrous impact on the right to livelihood, which is part of the right to life. The legal sanction to protect different segments of environment in India has been provided by successive enactments and laws. The main objective of the Wildlife Protection Act 1972 is to protect the wild animals and birds, particularly the rare species, such as the lion and the great one-horned rhino, which are fast disappearing. The Wildlife Protection Act was followed by the Water, Prevention and Control of Pollution Act of 1974. This is another major and significant act in environmental protection in India. The act came into force in 12 states. The objective of the act is to prevent and control water pollution and also to maintain and restore the wholesomeness of water. For achieving the objectives of this act, provisions were also made for setting up of central and state boards for prevention and control of water pollution in their respective areas. Of all the environmental problems facing the country, the problem of deforestation has received maximum public attention. In the Forest Conservation Act 1980, the central government may constitute an advisory committee to advise the government regarding grant of approval under Section 2 and any other matter connected with the conservation of forests, which may be referred to by the central government. The central government makes rules for carrying out the provisions of the Act. The Air Prevention and Control of Pollution Act 1981 is another important act which has been passed by the Government of India. The Act makes provision for the prevention, control, and abatement of air pollution and for the establishment of boards for conferring powers and functions relating to matters connected therewith. These boards have been empowered to establish air laboratories to enable them to perform their functions efficiently. The Bhopal gas tragedy of 1984 led to the speedy progress towards environmental protection in the 1980s. The Environment Protection Act 1986 was framed to prevent other such mishaps. This is a more effective and bold measure to fight the problem of pollution as compared to all the previous laws in this regard. Then came the Green Tribunal for Green Governance. The National Environmental Tribunal Act 1995 was enacted in view of the fact that civil courts litigations take a long time, as it happened in the Bhopal case. The act was to provide strict liability for damages arising out of any accidents occurring while handling any hazardous substance, and establish a national environment tribunal for effective and expeditious disposal of cases arising from such accidents. The main objective of the Act is to give relief and compensation for damage to person, property, and the environment. The National Green Tribunal was started in 2011 by the Ministry of Environment and Forest for effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources. It is a specialized body equipped with the necessary expertise to handle environmental disputes involving multidisciplinary issues. The tribunal's dedicated jurisdiction in environmental matters shall provide speedy environmental justice and, of course, help reduce the burden of litigation in the higher courts. Keeping in mind the emerging environmental scenario and to strengthen and make the existing laws more comprehensive, the MOEF prepared a draft in 2004 for the new Environment Policy of India, which finally became effective in 2006 as the National Environment Policy 2006. It does not displace but builds on the earlier policies. Sustainable development concerns in the sense of enhancement of human well-being broadly conceived are a recurring theme in India's development philosophy. The present-day consensus reflects three foundational aspirations. First, human beings should be able to enjoy a decent quality of life. Second, humanity should become capable of respecting the finiteness of the biosphere. And third, that neither the aspiration for the good life nor the recognition of biophysical limits should preclude the search for greater justice in the world. The National Environment Policy is also a response to India's commitment to a clean environment. mandated in the Constitution in Articles 48A and 51A and strengthened by judicial interpretation of Article 21. It is recognized that maintaining a healthy environment is not the state's responsibility alone, but also that of every citizen. A spirit of partnership should thus be realized throughout the spectrum of environmental management in the country. While the state must galvanize its efforts, there should also be recognition by each individual, natural or institutional, of its responsibility towards maintaining and enhancing the quality of the environment. The scheduled tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006 is a key piece of forest legislation passed in India on 18th December 2006. It has also been called the Forest Rights Act or the Tribal Rights Act. The law concerns the rights of forest-dwelling communities to land and other resources denied to them over decades as a result of the continuance of colonial forest laws in India. Supporters of the Act claim that it will redress the historical injustice committed against forest dwellers, while including provisions for making conservation more effective and more transparent. It makes provision of ownership over land that is being formed by tribals or forest dwellers, rights of local people to minor forest produce, to grazing areas, and provision of rehabilitation in case of illegal eviction or forced displacement, and gives forest management rights to local people to protect forests and wildlife. Let's now have a look at the role of judiciary toward green governance in India. The Government of India has taken a large number of steps in the constitutional, legal, and administrative fields in order to protect the environment from further degradation and pollution. In spite of such efforts made on part of both the central and state governments, the problem of environmental degradation and pollution has not been controlled to the extent to which it could have been. A number of reasons are responsible for this. Firstly, most provisions of the administrative and legislative laws remain only on paper or are twisted out of shape during their implementation. Secondly, lack of proper coordination and cooperation among the administrative institutions is an important loophole in the whole institutional setup. A further weakness of the present official program for environmental protection is its lack of recognition of the crucial role that NGOs can play in complementing the government's own efforts. From a legislation point of view, Loopholes in the Environmental Protection Acts have hindered the progress of implementation, as the executive has repeatedly failed to secure environmental safety and protection. People seek redressal from the judiciary. So, the judiciary has strenuously endeavored over the past 2 decades to bring in laws for the service of the poor and disadvantaged sections of society. In the early 1980s, the role of the higher judiciary in India underwent a transformation. A new and radically different kind of case altered the litigation landscape. Instead of being asked to resolve private disputes, the Supreme Court and High Court judges were asked to deal with public grievances over flagrant human rights violations by the state, or to vindicate the public policies embodied in statutes or constitutional provisions. This new type of judicial business is collectively called as public interest litigation, or PIL. Most environmental actions in India fall within this class. And incidentally, I do hope that you have seen my earlier video on PIL, that is public interest litigation also. We now move on to public interest litigations in environmental cases. Our judiciary has exhibited an enlightened judicial creativity and foresight whenever it has an opportunity to decide issues relating to environment. A survey of the numerous judgments of high courts and the Supreme Court show that most of the technical hindrances have been brushed aside by devising new tools of legal interpretation and construction. The landmark judgment of the Supreme Court in Ratlam Municipality versus Vardhichand 1980 is representative of the new outlook of the judiciary towards environmental conservation. In this case, the Supreme Court laid down two founding principles. One, that no municipality in India can put forth lack of money as a ground for not discharging its primary duty of looking after the health and safety of its residents. 2. The absence of public conveniences and the prevention of industrial pollutants to the detriment of the citizens' health are violations of the human rights of decency and dignity, which are non-negotiable first charges on a municipality. In the Dehradun quarrying case, Rural Litigation and Entitlement Kendra Dehradun versus State of UP 1985, for the first time, the Supreme Court held that the fundamental right to a wholesome environment is a part of the fundamental right to life in Article 21 of the Constitution. The question of water pollution, especially that of the river Ganga, came up before the Supreme Court in the case of M.C. Mehta versus Union of India. This river passes through the industrial belt of 3 states, and most of the industries are tannery and leather industries. The Supreme Court ordered the closure of 30 tanneries of Kanpur, which were releasing untreated effluents into the Ganga River. The court recognized that the closure of the tanneries might cause unemployment, but held life, health, and ecology have greater importance to the people. The judiciary has come up to its judicial activism by giving new dimensions to the right of life and personal liberty guaranteed by Article 21 of the Constitution. Right to healthy environment has been made and construed as fundamental right by the apex court while deciding various public interest cases filed by the enviro legal expert Mr. M.C. Mehta. Article 21, which gives right to life, includes all attributes which are necessary for the enjoyment of life. The Supreme Court, among other things, pointed out that 1. The government should evolve a national policy for location of chemicals and other hazardous industries in areas where population is scarce and there is little risk to the community, and care should be taken to minimize the pollution. Second, the Government of India should set up an ecological science group consisting of independent, professionally competent experts in different branches of science and technology, who would act as an information bank for the court and generate new information according to the particular requirements. Third, environmental courts should be set up with one professional judge and two experts drawn from the ecological science research group. Fourth, a principle of absolute liability should be there to compensate the harm caused to the persons due to environmental pollution. Next, the measure of compensation must be correlated with the magnitude and capacity of the enterprise, because such compensation must have a deterrent effect. This will also become in consonance with the legislative intention when they provided increased maximum punishment in the Environment Protection Act 1986 for its violation. A historic judgment was delivered by the Supreme Court in the Delhi gas leak case. Yes, once again, M.C. Mehta versus Union of India. The petitioner had alleged the infringement of the right to life of several thousand people due to severe pollution and hazardous activity of Shriram Foods and Fertilizers, manufacturing oleum and chlorine, situated in the heart of the city of Delhi. The Supreme Court ordered the management to pay compensation to the victims of oleum gas leak. It allowed the partial operation of the plant after laying down several conditions to ensure maximum safety of the workers and the community living in the surroundings. Thus, the court not only widened the scope of Article 21 by including in it protection of environment, but also included a liability in tort for those harmed by pollution. The Supreme Court has shown its deep concern regarding vehicular pollution in Delhi. In MC Mehta versus Union of India, 1998, the Supreme Court pointed out that keeping in view the mandate of Articles 47 and 48A of the Constitution of India, it has issued directions from time to time with a view to tackle the problems arising out of chaotic traffic conditions and vehicular pollution in Delhi. The Supreme Court, in order to control the vehicular pollution in Delhi, said that the following steps should be taken immediately as delivered by its order dated 28 July 1998. First, implementation of directions to restrict plying of commercial vehicles, including taxis which are 15 years old, by 2nd October 1998. Second, restriction on plying of goods vehicles during the daytime shall be strictly enforced. Third, expansion of pre-mixed oil dispensers, petrol and tutti oil shall be undertaken by 31st December 1998. Fourth, ban on supply of loose tutti oils at petrol stations and service garages shall be enforced. In 1985, MC Mehta once again moved the Supreme Court seeking direction to relocate 1,200 polluting industries away from Delhi. Contrary to the provisions of the Master Plan of Delhi, formulated in 1962, industrial units were operating in residential and non-conforming areas and causing pollution to the environment. Estimates placed the number of units at over 1,27,000. At least 10% of these units were hazardous industries. The Master Plan of Delhi became the basis of the judgment delivered by a division bench on 8th July 1996 that first, 168 hazardous industries be moved from Delhi to suitable locations in the NCR or closed by 3rd November 1996. Second, 513 and 334 units operating in residential and non-conforming areas be relocated between 30th January 97 and 30th June 97. Third, the Delhi administration should ensure that 39,000 units operating in non-conforming areas be either relocated or closed down. As a result of the Supreme Court order, 168 hazardous or large industries were closed or relocated by November 1996. And further, more than 1 lakh units operating in non-conforming areas had also been closed or relocated from Delhi. Now, these judgments make it clear that judiciary has exhibited its dynamism in evolving new dispensations to tackle the problem of pollution control. The doctrine of public interest litigation, replacement of punitive sentencing policy with a new sentencing policy based on affirmative action, judicial search for less harmful alternatives of economic development plans. Its attempts to encourage social activists to enforce social rights through cost avoiding techniques are all part of the new judicial activism. There has been a lot of hype over the environmental issues in our country during the last few years. There have been many agitations to conserve the natural habitats when dams were constructed, like the Narmada Bachao Andolan. Not only this, the American Enron power project at Dabhol had to face agitations against the environmental hazards of storing naphtha. Reliance's Jamnagar refinery had to face similar situations. Supreme Court judgments on environmental issues, ban on plastic bags, and implementation of Bharat Stage emission standards norms also reflect the rising environmentalism in India. The Government of India, recognizing the severity of these problems, has adopted a comprehensive policy to address the environment. India was the first country to insert an amendment into its constitution, allowing the state to intervene and to protect public health, forests, and wildlife. Besides the Central Pollution Control Board that was constituted in 1974, a full-fledged Ministry of Environment and Forests was established in 1985 to implement the environmental laws and regulations. Various laws to protect the natural environment, such as the Water Prevention and Control of Pollution Act 1974, the Air Prevention and Control of Pollution Act 1981, and the Environment Protection Act 1986 have also been legislated. Even a voluntary environmental labeling scheme, that is, Ecomark, has been launched for informing the consumers about the eco-friendliness of the products. Now, this is a certification mark issued by the Bureau of Indian Standards to products conforming to a set of standards aimed at the least impact on the ecosystem. The marking scheme was started in 1991. Governmental and non-governmental organizations have been making efforts to educate consumers about the environmental issues. For instance, the Bhagidari program had been launched by the Government of Delhi to create awareness about environmental issues among the citizens of Delhi, under which it initiated campaigns like anti-littering and anti-plastic bag campaign, Eco-Care program, Environment and Sanitation Drive, Keep City Clean Drive, Anti-Firecrackers campaign, Khelo Holi Naturally campaign, Clean Yamuna campaign, and many more. Besides, the Ecomark scheme was launched for the labeling of eco-friendly products, that is, those products which during the cradle to grave cycle, manufacturing, use, packaging, distribution, consumption, disposal, and recycling do not degrade the environment. In India, rapidly growing population along with increased economic development has placed a strain on the country's infrastructure and the environment. Deforestation, soil erosion, water pollution, and land degradation continue to worsen and are hindering economic development in rural India. Rapid industrialization and urbanization in India are also serious concerns. Industrial development has contributed significantly to economic growth in India. However, not without an environmental price. Not only industrial pollution is increasing public health risks, but abatement efforts are also consuming a significant portion of India's GDP. One of the major severe environmental concerns in India is air pollution, caused mainly by vehicular emissions and untreated industrial smoke. Apart from rapid industrialization, urbanization has resulted in the emergence of industrial centers without a corresponding growth in civic amenities and pollution control mechanisms. According to the World Health Organization, New Delhi is one of the top 10 most polluted cities in the world. Moreover, much of the nation's water is polluted because of raw sewage and runoff from agricultural pesticides. Now, this is an extreme problem in India because many of the people bathe and get their drinking water from the same rivers they empty their waste into. Soil erosion and desertification are other problems hurting many of the local farmers in the country. Many areas once covered by dense forests have turned into deserts due to centuries of overgrazing and agriculture production. India is one of the participants of the Stockholm Conference 1972, the first international meeting on environmental protection, which shows its consciousness to environmental issues. There can be little doubt that the Indian state has since independence passed a number of laws, rules, and regulations to protect the environment. India is one of the very few nations in the world which has enshrined in its constitution a commitment to environmental protection and improvement. Despite these initiatives of the government and the constitutional provisions, the problem of air, water, and noise pollution are on the increase. The main reason for this is the non-implementation of these provisions to protect the environment. Over the past 4 decades, the Indian Supreme Court has not only played a significant role in environmental protection, it has also secured a firm foothold in the environmental governance arena. The environmental judgments of the court, in many cases, have significant impact on the overall environmental governance process in India. Judicial activism, particularly in recent times, has given new direction in the protection and improvement of the environment. Another challenge faced by India is meeting the energy requirements in a sustainable manner. Currently, India is ranked 6th in the amount of greenhouse gases that it puts into the atmosphere because of extensive use of coal as the primary source for energy generation. With a rapidly growing population, the demand for electricity generation is on a rise. The alternative sources of energy are being explored in the country. Being endowed with rich water and wind resources, renewable energy sources such as hydroelectric power and wind energy are two of India's primary solutions to meet the needed increase in electricity generation. And these are being duly promoted by the government. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. The intention of this video is only to prepare candidates for answering examination questions on the subject. Do like and share this video, and do subscribe to my channel now so that you do not miss out on my previous or future videos. And if you desire to drop in a line, I shall always be available at sumitacademy20@gmail.com. Till later then, cheerio.